Now, we are looking at a typical exam question. It's on page 52 of your handout. We're asked to advise Mary in relation to any potential breaches of Section 13 and Section 14 of the Sale of Goods Act. We've now done the rough work. We've identified the main issues, so we'd like to answer this question in full. Now, we've already done the intro last night. We had to establish that it is the Sale of Goods Act that applies anyway. Just because you are asked to advise on the Sale of Goods Act, you must check yourself if it is indeed the Sale of Goods Act. You do that by checking that the CRA does not apply. Then, because this question tells you that Mary part exchanged her old machine and there is the possibility that Shabby did the installation, you also had to query whether this is a Supply of Goods and Services Act which applied. The conclusion is that actually it is the Sale of Goods Act. That's what we got to last night. Now, having established that, we know Mary has lots of complaints. The question is whether what she is complaining about amounts to breaches of the terms of the contract. We are specifically asked to advise on 13 and 14. Tell Mary, our client, straight away that if there is a breach of Section 13 and Section 14, these are implied conditions entitling Mary to reject the washing machine. This is, of course, subject to the court's Section 15 Big A discretion. 15 Big A, remember, overrides 13 and 14. So the breach is so slight that it is unreasonable for the buyer to reject. The breach of a condition can be treated as a breach of warranty only. The burden of proof is on the seller, Shabby. Now, as I say, now you can deal with each bit in turn. My preference is always to do 13 first, then 14, but only because that's the order that we handled it in our lectures. You can deal with 14 first if you want. It makes no difference at all. As long as you cover the same issues, of course, you will get the marks. Now, as far as description is concerned, Section 13 says it is an implied condition that where goods sold by description, goods must correspond with that description. In order for Section 13 to kick in, there must be an express term as to description. Now, the advert in the trade journal said lots of things. It said the washing machine was new, it was super eco-friendly, it was energy efficient. Not every statement about quality or fitness can be treated as part of description. Sometimes it is only a representation. Now, it's very important to distinguish whether a statement is a term or a representation. You and I know there are 5 factors the courts will bear in mind to determine whether a statement amounts to a term or a representation. In the exam, don't mention them all. Just highlight the ones you feel are relevant. We're told Shabby made statements in a trade journal. Well, we know that words in these types of adverts can amount to descriptive terms of the contract. The case is Beale against Taylor about a car being advertised as 1961 white Herald convertible. Now, one important factor the court will take into account is as to whether a statement is a term or a representation is reliance. In order for eco-friendly, super efficient to amount to a term of the contract, Mary must have relied or was influenced by the description in the trade journal. You would use Harlington and Leinster against Christopher Hull as your authority for that. Go through the facts of this important case about the 2 paintings supposedly by Munter. It was not true. The buyer sued for breach of Section 13. The court said there was no breach. The buyers were the world's experts on Munter paintings, so the buyer did not rely on the seller's description. They relied on themselves. So did Mary rely on the statements in the advert? Always tied into the facts you are given. We are told, aren't we, that Peter, the salesman, was very persuasive. Well, let's just hope that our client Mary did not enter into the contract purely because Peter offered a free 1-year extension to the standard manufacturer's warranty. As long as it was just one factor why she bought the machine, we can still argue that she contracted on the basis that the washing machine was advertised as new, super eco-friendly and energy efficient. Now, new, of course, you and I know already, it's likely to be a term of the contract. We know the case of Andrews against Singer. The contract was for new Singer cars. The court said new was an express term of the contract. Same as Mary's contract is for a new washing machine. So new will be an express term as a description. We're not sure about energy efficient and fast, though. Maybe those things are just representations. Remember, you don't have to find everything in favor of your client. As long as one thing is in favor, that's fine. We can relax about the others. So as far as new is concerned, we already know in advance. In our heads, we know new is an express term. Then we can talk about section 13. But as far as energy efficient, fast, maybe that stuff's only a representation. Sure, if the representation is false, then it might amount to an actionable misrep. But as I said yesterday, there's no need to say anything more about misrep. You need to concentrate on 13 and 14. Okay, so we've worked out that we have a term of the contract. The washing machine must be new. As it turns out, the machine is not new. It had someone else's clothes in it, for heaven's sakes. So there is a breach of the express term that the machine must be new. But is that express term a condition, a warranty, or an intermediate innominate term? Because this will affect the remedy available to Mary. Courts will probably treat the breach of the express term as a breach of an innominate term. So the remedy would depend on the seriousness of the breach. If the consequences of the breach deprives the innocent party of substantially the whole benefit which she was to obtain under the contract, the innominate term will be treated as a breach of a condition. But if the consequences are not too serious, the intermediate or innominate term will be treated as a breach of warranty only. Now, Hong Kong Fur Shipping against Kawasaki Kaisen is an important case. I don't think the facts are crucial, but Hong Kong Fur comes up all the time. Whenever the question involves section 13, you know there needs to be an express term first. This means if there is a breach of the express term, you always need to refer to Hong Kong Fur. So although the facts of the case are not crucial, it is important to say that the remedy of a breach of an express term depends on the consequences which flow from that breach. If the result of the breach did not deprive the innocent party of substantially the whole benefit which he was to obtain under the contract, then the breach of the express term will be treated as an innominate term, more like a warranty. This means the innocent party is not entitled to reject the goods. Now, there are other important cases on this point, but you probably don't have the time, so the minimum is Hong Kong Fur. The point you are trying to make is that the washing machine that was delivered to Mary was not new. This is a breach of the express term, sure, but how serious is that breach? Maybe not that serious, because Mary could still use it as a washing machine. In fact, we're told in this question that Mary didn't want to make a fuss. So maybe even Mary didn't think new or nearly new made much difference. So the courts may only allow our client Mary to treat the breach as a breach of warranty only. But of course, the big thing is, once there is an express term as a description, then section 13 kicks in. Section 13 says there is an implied condition that goods must correspond with that description. Remember, courts have a discretion these days under section 15 big A. 15 big A overrides section 13. 15 big A says, if the breach is so slight that it is unreasonable for the buyer to reject, the court has a discretion to treat that breach of a condition and reduce it down to a breach of a warranty only. The burden of proof, of course, is on Shabby to show that the breach is slight and it would be unreasonable for Mary to reject the machine. One point you want to make is what amounts to description for section 13 purposes. You see, there is no definition under the Sale of Goods Act. What is clear, though, from case law is that if the buyer has not seen the goods, the sale must necessarily be one by description. The case authority is Varley against Whip. The seller did not even own the reaping machine yet, but he told the buyer that the reaping machine was nearly new and hardly used. The machine, when it was delivered, was old and clearly being used extensively. The court held that nearly new and hardly used was part of the description of the goods because it identified the reaping machine. The question is, did our client Mary see that very machine she agreed to buy? I mean, She visited the shop, didn't she? But we're not told if she had agreed to buy this specific machine or whether the machine was unascertained goods, because the machine was in Shabby's warehouse. It doesn't matter in a way because of section 13, subsection 3. Because section 13, sub 3 says, if the buyer selects goods, it can still be a sale by description. The case authority, of course, is Beale against Taylor. That's the case about the 1961 White Herald convertible. So you see, sales in Shabby's shop is covered. Just, in other words, goods displayed is a sale by description. The washing machine must be new. It must be energy efficient and so forth. But we know that not all words form part of the description. We know the case of Ashington Piggeries against Christopher Hill. I won't remind you the full facts of this case, but you must learn how to abbreviate it. This was the case about the manufacture of mink food. The House of Lords said, on the facts of the case, there was no breach of section 13. Diplock said goods were properly described as herring meal. Just because the herring meal was contaminated, it does not mean that the goods have lost their identity. Contaminated herring meal was still herring meal. The defect in the herring meal was a matter of quality, not description. So the question is, if the machine is not eco-friendly and it's not energy efficient, do those defects alter the identity of the washing machine? What about the fact that the washing machine is slow? Does that alter the description of the machine? Remember, section 13 is subject to the strict compliance rule. Sure, it's subject to 15 big A these days, but Arcos and Rodesen is a good case to illustrate the strict compliance rule. The wooden staves were only 1/16 of an inch too thick. Nevertheless, the court said the seller was in breach of section 13. Remember, Atkins said, if the seller wants a margin, he needs to expressly say plus or minus. Otherwise, it needs to be exact. Hazelwood against Lion Foods is also relevant. I won't remind you of the full facts. It was about the chili powder, which was contaminated with Para Red. Now, in this question, of course, Mary does suffer loss. Section 13 is strict anyway. In fact, it doesn't even matter if a buyer suffers damage or not. They can always claim breach of 13. Read Moore and Landauer is your case authority. That was the case about 3,000 tins of fruit, which were packaged incorrectly. The court said that was a breach of section 13. Now, Shabby said the machine was new. What was delivered to our client does not sound new. It had someone else's washing in there. This will definitely be a breach of section 13. Now, an important case to mention too is Reardon against Hansel. You won't have time to give the full facts of this case, so just abbreviate it. The case involved a ship which was not built at yard number 354, but it was built 300 miles away. The buyer claimed this was a breach of contract. The House of Lords said there was no breach of section 13. Wilberforce said yard number 354 was just a name. It does not form part of the description for section 13 purposes. It served no purpose at all because the description needs to focus on the goods. The reason why Reardon is a good case to talk about is because, you see, in our question here, the machine was labelled Fast Spin 200. Now, brand and model name does form part of the description. But, of course, presumably, what was delivered was a Fast Spin 200. But what Mary is complaining about is that the machine is very slow. Now, quality does sometimes form part of a contract description. Denning, in Topfer against Continental Grain, he said new laid eggs goes to both description and quality. So there is no problem in this question for Mary to sue for both section 13 and section 14. Shabby does, after all, sell in the course of business. So section 14 claim is available to Mary as well as section 13. But the thing is, I'm not so sure if fast is part of the description of the machine that Mary bought. It's probably a matter of quality, like the herring meal in Ashington Piggeries. Of course, the model name of the machine is Fast Spin. It does sort of suggest that the machine should be fast. No doubt, Shabby will argue that it's only a brand name and it does not form part of the description. It just might be possible to argue that Fast Spin is an integral aspect of the description, and it was relied on by our client in deciding to purchase it for the business. So maybe it does form part of the description. I mean, to be frank, I think it's unlikely, but it is possible. After all, Denning in Topher did suggest that new-laid eggs or free-range eggs implies not only that the eggs are new-laid or free-range, but the words suggest that they are of higher quality. In the same way, Shabby claims that the washing machine is energy efficient. Well, again, it is possible, but it's unlikely that energy efficient forms part of the description of the goods. It's really more of a quality issue. As I say, you do not need to find that everything the client is complaining about is a breach of Section 13 and a breach of Section 14. For sure, if the washing machine is not new, that is definitely a breach of Section 13. So long as you mention the other issues, like Mary says, oh, the machine is slow and not energy efficient, say it could be a Section 13 issue, but in your opinion, probably not. Now, move on to Section 14, which is a big one. You just need to establish that Section 14 applies anyway. All you need to do is to make that point. 14 applies whenever a seller sells in the course of business. Shabby definitely sells in the course of business. You could give the case authority of Stevenson against Rogers. Even a fisherman selling his old fishing boat, he sells in the course of business. Having done that intro, now going to Section 14.2. 14.2 says there's an implied condition that goods must be of satisfactory quality unless. Remember, there are two exceptions. Unless the defect was brought to the attention of the buyer, or that examination the buyer carries out ought to have revealed the defect. Always make sure that the exceptions do not apply in your question. Of course, exam technique tells you that they won't apply, because if they do apply, your answer will be very short. But you need to discuss them in order to get the marks. So say that Mary probably did not see the actual washing machine before the contract. She only sees it on delivery. So she will not have examined the machine at Shabby's shop. So the first exception does not apply. Shabby would not have told her about the defect. The second exception is that the buyer brought the defect to the buyer's attention. Of course, this is not going to apply. I mean, Peter, the salesman, would not have said to Mary, oh, by the way, the washing machine is going to stop working soon after delivery. Of course not. So just conclude that the exceptions do not apply. But if you don't tell us you've thought about the exceptions and you've got rid of them, you won't get the full marks. So having done that, got rid of the exceptions, now you go into the definition of what you mean by satisfactory quality. 14.2a is where the definition comes in. 14.2a says goods are of satisfactory quality if a reasonable person would regard the goods as satisfactory, bearing in mind three things: description, price, all other relevant circumstances. Go through each of these in turn. Go through description. Well, here, are we told whether she's bought a new and second hand? Well, yeah, we are. We're told that Mary bought a new washing machine. Well, we've got two car cases to do with new. The first one was Rogers against Parish. Rogers and Parish involved a brand new Range Rover. Rogers against Parish is the case where Mr. Justice Mustall said a very high standard is required for a brand new car. Now, of course, we're only talking about a washing machine in this question. So it's not quite the same thing as having the pride and joy of driving a brand new car. So I think I wouldn't mention what Mustall was saying about buying a brand new car includes the pride and joy of driving it. Because after all, we're just talking about an industrial washing machine. The other brand new car case we know is Bernstein against Panzer Motors. Brand new Nissan. Remember, it broke down after almost no use at all. The court said, of course, that is a breach of quality. We're looking at the definition of satisfactory quality. We said that description is important. Now, price is also important. How much did Mary pay? We're told she paid £3,000. Well, that's not cheap. We have cases dealing with this. Go through Brown against Craig's. That's the case about cloth. The other case is Sembrit against Apex Roofing, involving the sale of roof tiles. Now, I'm not going to remind you of the facts, we've done that already. In this question, we're told that the machine was sold to Mary at a knockdown price, £3,000. Usually we're told it's £5,000. But this does not mean we should expect reduced quality. No way. £3,000 is not a throwaway price. Goods are maybe just on sale. Maybe Shabby discounted the price to move stock. So what we ought to do, I suppose, is to check to see what washing machines typically cost with the same features and functions, just to see where in the range this model and brand lies. Is it mid-range? Is it high-end? But remember, description and price are not separate tests. Go through the case of Felderon Foundry against Hermes Leasing. This was about the second-hand Lamborghini costing £65,000. Now, I don't have the time to remind you of the facts of these important cases. Anyway, we already did this topic in yesterday's lecture, so you need time to digest the facts anyway and write up your lecture notes. We're asking whether the washing machine is or is not of satisfactory quality. 14.2a says goods will be satisfactory if they meet the standard that the reasonable person would regard as satisfactory. We are told Mary notices deep scratches on all sides of the machine. We're not sure this in itself would render the washing machine unsatisfactory. But if the washing machine breaks down after a repair, and all of this was within about 3 weeks, I reckon that washing machine is not of satisfactory quality. The question, of course, is when must goods be satisfactory anyway? The answer is at the time of sale and delivery. The case authority is Crowther against Shannon Motors. The court said, if goods are defective after a short period of time after sale, that is evidence that at the time of sale, the goods were already defective. The other case you could include is Hazelwood against Lion Foods. No need for facts because this question about the washing machine, not that similar. That's similar anyway. But you could, if you wanted to, you could say in Hazelwood against Lion Foods, the FSA had zero tolerance as far as para-red was concerned. The court held that this amounted to a breach of section 14.2 and 14.3 at the time of sale and delivery. So you see, you have abbreviated the facts of the case to the bare minimum, but it shows you know the case. Because when you say things like FSA, when you say things like para-red, these words are the exclusive facts of the Hazelwood case. Okay, so we will give you marks because we know you know the full facts of the case, but I'm mentioning just those brief words. 14.2a says goods are satisfactory if a reasonable person would regard the goods as satisfactory, bearing in mind description, price, and all other relevant circumstances. We are told Shabby refused to offer any further assistance and they referred Mary to her manufacturer's warranty. Of course, you must 100% discuss Lamara against Capital Bank. Brand new Range Rover, £51,000. Very minor defects included the ashtray, which is a little bit scratched. The glove box was not quite straight. The seller argued, hey, these defects are easily rectifiable and is covered by the Range Rover warranty anyway. The seller said it was unreasonable to refuse the offer to remedy the defects. Court said the warranty was not a relevant circumstance to determine whether the goods are satisfactory or not. Remember, the reasonableness or unreasonableness of the buyer is not relevant at all. Why should a buyer who has a warranty be in a less position than a buyer with no warranty? If the buyer has the right to reject, the buyer can be as unreasonable as he wants. Now, of course, sure, we have section 15 big A, but Mary's machine breaks down. This is not a slight breach. I doubt whether the courts will exercise 15 big A. Now, something we didn't talk very much about yesterday was 14.2b talks about aspects of the quality of the goods. Now, we know that aspects of quality of the goods includes fitness for all purposes for which goods of this kind are commonly supplied. That bit we did discuss. But there were other aspects as well: appearance and finish, freedom from minor defects. We have a case on this, Darren Egan against Motor Services. The facts of this case don't really matter, but what the court said was important. The court said freedom from minor defects did not mean literally every minor defect. It depends on whether a reasonable person would think it was satisfactory or not. But here in our client's case, there are so many defects. There's water leakage, the door was jamming, and eventually it breaks down. These are not minor faults. Another aspect of the quality of goods is safety. Now, we're told the door jams. Well, if the door jams, then the washing machine is not very safe, is it? Especially if water leaks onto the floor. This could be a health and safety issue for customers. Another aspect is durability. All of this is happening after about 3 weeks. A brand new washing machine stops working within 3 weeks. No way. Hardly durable, not of satisfactory quality. As we said, goods must be satisfactory at the time of sale and delivery. Crowther against Shannon Motor says, because the goods are defective after such a short period of sale, that is evidence. At the time of sale, the goods were already defective. In this question, the washing machine is supposedly a heavy-duty one. But there is the criticised House of Lords decision in Kendall against Lillico. This was the case about groundnut extract used for the manufacture of animal feed. It was poisonous to both cattle and poultry, but in different degrees. It proved lethal to pheasants. The House of Lords said no breach of section 14.2. The extract was satisfactory for the manufacture of animal feed. Remember, this is where the House of Lords used the acceptability test. The House of Lords said, if the buyer knew that the extract was poisonous, the buyer would have accepted the goods anyway, because he could have used a label before he sold it on to his buyer. If a buyer would accept goods, then the goods are satisfactory, no breach. Now, although this acceptability test has been criticised, in fact, it helps our client Mary, doesn't it? Because if Mary had known that the washing machine would break down and have all those other problems, it is unlikely Mary would have accepted the machine. So there would be a breach of 14.2. There is no way a reasonable person would accept the washing machine in this terrible condition. We're told the machine leaks when it is in use. You see, maybe we should query whether the leak is because of the machine itself, or maybe because there was faulty installation. Because if installation was faulty, then this is a breach of the implied term under section 13 of the 1982 Act. We haven't done the 1982 Act yet, but we will. It's our next topic. Section 13 of the 1982 Act says a supplier must carry out his service with reasonable care and skill. Now, in this question, all you would have to do is just to mention it. Don't go into any detail because you are asked to concentrate on 13 and 14 of the Sale of Goods Act. If the washing machine was incorrectly plumbed in, just say that's a problem. That's a breach of section 13 of the 1982 Act, and just leave it there. Now, having done 14.2, now you go into section 14.3. 14.3 says, where the buyer expressly or impliedly makes known his purpose, it is an implied condition. The seller must provide goods fit for that particular purpose. Again, there are two exceptions to 14.3, which we'll look at in a second. The buyer must have expressly or impliedly made known his purpose. Now, Mary is buying a washing machine. She doesn't have to expressly say why she's buying a washing machine. We know the hot water bottle case, Priest against Last. This applies to goods which have one use only. So the description of the goods washing machine, it points to one purpose only. So shabby must supply goods fit for that purpose. We also know the case of Grant against Australian Knitting about the underwear. We also know the case of Griffiths against Peter Conway about a wool jacket. A washing machine only has one purpose. The machine our client bought, it leaks, the door jams, it breaks down. I think there's very clearly a breach of 14.3. We said there are two exceptions. I don't think they apply in this question because it is reasonable for Mary to rely on Shabby's judgment to provide a washing machine that works. Now, we know the case of S.T. Belton against Tehran Europe about the air compressors sold to a buyer in Persia. Also mentioned that the House of Lords in Ashington Piggeries against Christopher Hill said, if the seller knows the purpose of the goods, the presumption is that the buyer relied on the seller's skill and judgment. I'm just wondering, actually, might Shabby argue that Mary was in the same sort of business, and so maybe Mary did not rely on their skill? After all, Shabby sells washing machines. Mary has a laundrette business, so maybe Mary did not rely on Shabby's skill and judgment. Well, Shabby can try and argue that point, but the court in Kendall against Lillico said, even if the seller and buyer are in the same trade, this does not mean that there is no reliance. So Mary can still rely on Shabby to provide her with an industrial washing machine fit for her purpose. After all, she runs a laundrette business. She can't be expected to know every tiny thing about the components of these machines. Anyway, the burden of proof is on Shabby to show that there was no reliance or it was unreasonable for Mary to rely on Shabby. The conclusion is that where goods are supplied, they have only one purpose. It must be fit for that one purpose. Please don't finish there. Go on to say it does not mean that the goods need to be fit for every conceivable purpose, because we need to check that Mary was using the washing machine in a normal way. If goods are not satisfactory nor fit because of something the buyer did or the buyer did not do, then the seller is not in breach of section 14. The case authority is Balmoral against Borealis. Go through the facts. The tags were made from the Boresine were no good because it was the buyer's misuse of the Boresine that caused his loss. So we need to ask if Mary used the washing machine properly. Assuming she used the machine in a normal way, then the machine clearly does not perform even its basic function, so it will not be satisfactory nor fit for purpose. Occasional problems may be okay because washing machines are very complex electrical items, but Mary's problem with the machine are much more serious and they're fundamental. For sure, you could say, section 14.3 imposes strict liability on the seller, even if there is no means of detecting the defect. Seller must supply goods fit for the buyer's purpose. There are no excuses. Remember, we looked at the case of Frost against Aylesbury. That was the case about typhoid found in milk. So, having talked about 14.2 and 14.3, conclude, say it looks as though there is a breach of 14.2 and 14.3. These are implied conditions, but it does not mean that Mary is entitled to reject the machine, not if she has accepted the goods. So now discuss acceptance. Always start with section 34. Section 34 says a buyer must be given a reasonable opportunity to examine goods. The right to examine can be waived or excluded by the contract, but there's no indication in this question at all that Mary agreed to waive her right to examine on delivery. Because breaches of the implied conditions under sections 13 and 14 impose strict liability, it means Mary does not need to establish fault on the part of Shabby. The defects of the washing machine go to the central function of the machine, and they are significant. These are very serious breaches, as we said, so we don't think the court will exercise 15 big A discretion. But the point is, under section 35, a buyer can lose his right to reject in three ways. The first way is where the buyer expressly intimates acceptance. Nope, that doesn't apply. Nothing like that in this question. The second way is the buyer can be deemed to have accepted the goods if the buyer does an act inconsistent with the seller's ownership. We know the case of Greg against Emhart Glass. There was a breach of Section 14, but the buyer had accepted the machines. He had used them for 2.5 years after all. But in effect, this merges with the third way the buyer can lose his right to reject. If the buyer retains the goods beyond a reasonable time without rejecting them, the buyer is deemed to have accepted them. Now, whether a reasonable time has elapsed, that depends, of course, on whether the buyer has had a reasonable opportunity to examine the goods, to ascertain if they conform with the contract. Of course, this always depends on how complex goods are. Here, we're talking about a washing machine. How long has Mary had the washing machine? Well, the question says Mary agreed to buy the machine on the 10th of January. It was delivered the next day, we're told, so it was delivered on the 11th of January. When does she complain? She complains on the 26th of January. So Mary has had the machine for 15 days before she complains. So the question is 15 days too long? Now, in Bernstein against Pamson Motors, 3 weeks was too long. Okay, sure. I know the case was settled out of court, but Bernstein still indicates, kind of shows you that 3 weeks is kind of maybe okay for a car. But a car is much more complex than a washing machine, surely. But you should point out too, that just because a buyer continues to use the goods, it does not mean the buyer has lost his right to reject. The case is Clegg against Anderson. The court said Mr. and Mrs. Clegg had not accepted the yacht within the meaning of Section 35, even though they had had the yacht for more than 6 months. That's because they were waiting for information from the seller. When they got the information, Mr. and Mrs. Clegg rejected the yacht within a reasonable time. 3 weeks was a reasonable time. Compare that case with Jones against Gallagher. Mr. and Mrs. Jones noticed that the cupboards were the wrong colour almost straight away, but they did not reject until 5 months later. The defects were patent. Court said Mr. and Mrs. Jones had lost their right to reject. Here, we're talking about a washing machine. Now, Mary noticed lots of scratches almost straight away, and she also clearly knew that the machine was not new. If the machine, it had other people's clothes in it, for heaven's sakes. So these defects are all very clear, all patent. I think Mary cannot reject because of these defects. But after only about 3 weeks, the washing machine breaks down anyway. Oh, by the way, of course, we're told that Mary allowed Shabby to repair. Very important to talk about Section 35 sub 6. 35 sub 6 specifically says a buyer does not lose his right to reject goods merely by letting seller try to repair them. Ritchie against Lloyd is an important case, not only because it is a House of Lords case, but it is directly relevant to this question. Because we're told that when Shabby returns the machine, apparently having repaired it, they refuse to explain to Mary what the problem was. The House of Lords had lots to say about this, so go through the facts of Ritchie against Lloyd. I won't remind you now, but you do need to give it in the exam. We're told Shabby refuses to tell Mary what the problem was when she took the machine to repair. The House of Lords and Ritchie said, where the buyer requests it, the seller must give information to the buyer as to what was wrong with the goods. The House of Lords said, the inspection and repair was a sub-agreement. It was a collateral contract. There was a breach of the collateral contract in Ritchie, so the farmer could treat the sub-agreement as repudiated and reject the equipment. In this question, Shabby refused to advise Mary about the nature of the defects, despite being asked to supply the information. Following Ritchie, I think Mary can reject. Now deal with remedies. As I say, I deal with remedies as a pack of 5 things. But even with the first thing, damages, you can see I split it into 2. Because If Mary can reject, the answer is blah, blah. If Mary has lost her right to reject, the answer is blah, blah, blah. So, first of all, if Mary can reject the washing machine, she is entitled to a full refund, plus she claims Section 51 damages for non-delivery. This is the market price rule under Section 51. Damages is the difference between the contract price and the market price. Say that Mary is expected to buy a replacement washing machine. Now, if Mary has to pay another supplier more than £3,000 she paid to Shabby, then she would be entitled to claim the difference against Shabby under Section 51. So it could be as much as £2,000, because we're told the normal price of this machine is £5,000. So 5,000 minus 3,000, 2,000. Now, if Mary has accepted the washing machine under Section 35, as we discussed, then Mary no longer has the right to reject. But it's not the end of the world, because Mary can claim Section 53 damages for breach of warranty of quality. This is the difference in value rule. In other words, the difference between the value of the goods to the buyer and the warranted value. But this is only a prima facie rule. It certainly does not take much to displace it. This is well illustrated by the case of Bent's Graphics against Fasten. This is an important case about vinyl film, which was used to make labels to stick on bulk containers. But I very much doubt you will have the time to give the facts of this case. But please give the case name as the minimum. If there is an available market, and why not? Because we're only talking about an industrial machine, it's not exactly unique, is it? If there is an available market, say that the warranted value is the market price. We're not told what the market price is, although we are told that the usual price of the machine was £5,000. If that's the case, the warranted value is the market price, which might be £5,000. So if the washing machine broke down and it's completely worthless, then Section 53 damages would be the difference between the market price of 5,000 and the value of the goods, which is zero. So Mary may be entitled to recover Section 53 under £5,000 under Section 53. In addition to damages either under 51 or 53, Mary may be entitled to claim for consequential losses. Now, we're not told anything in the question, but just mention that Section 54 damages would include buyer's loss of repeat of future orders from customers. Your case authority is GKN against Maxbro. I won't remind you of the facts, but just say that if Mary has angry customers because she can't do their washing, she can claim for loss of future orders. The third thing I would mention is mitigation. Once there is a breach, Mary must try and mitigate her loss. Mary is expected to go and buy a replacement washing machine to keep her laundrette business going, to try and reduce the disruption to her business and to her customers. The case authority is Peizu against Saunders. You won't have time, I am sure, to give the facts of the case, but you could just say that the buyer in Peizu against Saunders was not entitled to damages because he did not mitigate his loss. Of course, Mary only has to mitigate the loss by taking reasonable steps. Roth against Tyler. No need to give facts. The fourth thing I would mention is non-pecuniary loss. You see, Mary is running a laundrette business. Businesses can suffer mental distress because if Mary does not deliver a reliable washing machine to her customers and her customers have to queue up to use a washing machine that does not work, Mary's reputation as a reliable laundrette may be tarnished. Give the two cases we know. Gibbons against Westminster Bank, where the bank wrongly bounced a customer's check, damages was awarded for loss of reputation. Anglo-Continental Holidays against Topaltus. A ship owner cancelled a cruise at the very last moment. The travel agent was entitled to damages for loss of goodwill. Finally, and it's a bonus mark if you can mention it, type of loss. What I mean by this is that the statement is, it is the type of loss which determines whether the loss is recoverable or not the amount. We know two cases, Parsons Livestock against Utley Ingham about the dead pigs. We also know Jackson against RBS about importing dog food from Thailand. What we are using these cases to show is that Mary's loss could be fairly substantial here compared to the cost of the washing machine. But that's why I would finish off your answer by saying it's not the amount of loss that matters. If the loss is within the reasonable contemplation of the parties, then Mary's full loss is recoverable. Full stop. That's a pretty full answer. If you can do that in 1 hour, you would get top marks for that. All right, well, that's probably a very good place for us to take a 10-minute break. We'll come back and we will then look at supply contracts. All right, I'll see you in 10 minutes. Hi, okay, fantastic. We've now completed sections 12, 13, 14, and 15 of the Sale of Goods Act. Now let's look at supply contracts. Now, it is very important to decide if you have a B2B or a B2C contract. The way to do that is to work out whether the contract is governed by the CRA. The CRA only applies to consumer contracts. Of course, we will be studying the CRA later. For now, what you need to know is if Section 2 CRA definition of a consumer contract is not satisfied, then it is not a consumer contract. It's a B2B contract. If it is a B2B contract, then if it is a sale of goods contract, you look at Sale of Goods Act 1979. If it is a supply of goods contract and it involves a service, we look at the Supply of Goods and Services Act 1982. How do we decide whether the contract falls under the Sale of Goods Act or the Supply of Goods and Services Act? Well, the Sale of Goods Act only applies where the main purpose is the sale of goods. So if a builder installs an air conditioning unit in my office and the price agreed includes the sale of the unit itself and the installation, is this a sale of goods? Maybe yes, if the installation is only an incidental part to the sale of the contract, or sale of the unit. If the installation is a major part, then the contract does not fall within the Sale of Goods Act, but within the Supply of Goods and Services Act. Example, a contract for a brand new swimming pool. Well, this is more likely to be under the 1982 Act. I mean, okay, the lining of the swimming pool, the bricks, the tiles, etc. Yeah, that is the sale of goods, sure, but the main work is the building. In other words, the supply of a service. So look at the substance of the contract. If the substance is for skill and labor, then the 1982 Act applies. Example, a contract for painting a portrait. This will be under the 1982 Act because the substance is for the services, even if goods, the physical painting, is sold. That's the case of Robinson against Graves. The court said a contract to paint a portrait is a contract for skill and labor. Now, if substance is ultimately for goods, then it is the 1979 Act that applies. Example, a meal in a restaurant. Is it a contract of sale of goods or supply of goods? Actually, what do you think? When you go to a restaurant and you're eating dinner, you have your meal. Are you entering into a contract for the sale of goods with the restaurant, or are you entering into a contract for the supply and for supply of goods? Is it a sale of goods contract or a supply of goods contract? What do you think? The answer is sale, even though it involves the provision of services. So it is a bit confusing because when you have a meal in a restaurant, it is a sale, even though it's a provision of service. Having said that, a takeaway meal is a supply of goods. It seems a bit odd, but that's just how it is. Now, the Sale of Goods Act only applies where there is money consideration. So if there's no money involved, check, credit cards, yeah, these things all are fine. If there's no money involved, that is not a contract for the sale of goods, but a contract for the supply of goods. And the 1982 Act will apply. Supposing goods are exchanged for goods plus money. Is that a contract of sale? For instance, if the motor car dealer takes your old car in part exchange for a new car, is that a contract of sale? Or maybe you trade in your old iPhone for the latest iPhone. The answer is, it depends. You could look at the substance of the contract in the same way you might look at a swimming pool or painting a portrait. Is money or the goods exchanged the substantial consideration? Ultimately, it depends on the intention of the parties. So if parties intend the transaction to be a sale, then the Sale of Goods Act applies. Now, we saw this, didn't we, when we looked at the question about Mary and the washing machine she bought from SAGA, the question we just looked at. I mean, she part exchanged her old machine for a new one. We concluded that it was a sale of goods contract. The Sale of Goods Act and the 1982 Act are very similar indeed. In fact, there are only two main differences between the Sale of Goods Act and the 1982 Act. The first difference is acceptance. See, sale of goods is subject to the doctrine of acceptance. Under the 1982 Act, the buyer loses his right to reject if he affirms. Now, affirmation is usually a longer time than acceptance. We've seen the case, Felderol against Hermes Leasing. This was the Lamborghini case. It was a second-hand Lamborghini costing £65,000. In fact, in Felderol, it was not a sale of goods contract because the company had taken the car on finance. It was a hire purchase agreement, and the concept in hire purchase agreements is affirmation. So you lose your right to reject if you have affirmed the contract. In this case, the MD rejected the car 5 to 6 weeks later. The court said the MD had not yet affirmed. He can still reject. Compare that case with Bernstein against Panzer Motors, which was a sale of goods case. Brand new Nissan. When it was delivered to the old man, he was sick. And almost the first time he drove it, 3 weeks later, it broke down on him. The court said, sure, it was in breach of 14.2 and 14.3, but, they said, the buyer had lost his right to reject. 3 weeks was too long a time to examine the goods. Sure, I know I told you that this case went to appeal and they settled out of court. But the idea is, you see, in Felderol, when we're talking about affirmation, you get a longer time to examine the goods before you lose your right to reject. Whereas with sale of goods, it's a fairly short period of time before you are deemed to have accepted. If you accept, then you've lost your right to reject. The second main difference between the Sale of Goods Act and the 1982 Act is that the Sale of Goods Act has lots and lots of section numbers dealing with the transfer of property and risk. And we looked at Nemodat rules as well. Now, the 1982 Act doesn't have anything on the transfer of property and risk. It doesn't have anything on the Nemodat rules either. The 1982 is silent on most of these things. Only sections 12, 13, 14, and 15 of the Sale of Goods Act have been incorporated. The typical scenario is a construction contract for the building of an extension to a factory. There's a goods bit to the contract, and there's a service bit to the contract. The goods bit, the bricks, the cement, all that stuff, if that stuff is defective, then the answer is virtually the same as the Sale of Goods Act. Just different section numbers, of course, but it's not difficult to work it out. Let's do this together. Okay. You tell me, what is the section number for title under the Sale of Goods Act? What is the section number for title under the Sale of Goods Act? You tell me. Thank you very much. Perfect. Brilliant. 12. Tell me what the section number for description is under the Sale of Goods Act. What's section number for description? Excellent. You see, you guys are shouting out the section numbers already, and we are nowhere near the revision course. That's brilliant. Okay. What about satisfactory quality? What's section number for satisfactory quality? Thank you very much. Well, 14 is no longer good enough. 14.2 is what we're after. 14.2. Fitness for purpose. What's section number under the Sale of Goods Act? What's the section number for fitness for purpose? Super. Well done. Excellent. 14.3. And what about sample? What's section number for sample under the 1979 Act? Perfect. Brilliant. I agree. 15. Okay, so the section numbers under the 1982 Act are different, but it's not hard to work it out. Let me start you off. For title, under the 1982 Act, title is section 2. It says exactly the same thing as section 12 of the 1979 Act, but it's section 2. Take a wild guess what the section number is for description under the 1982 Act. Take a wild guess. Oh, very good. Your wild guesses are excellent. Section 3. Take a wild guess what the section number is for satisfactory quality under the 1982 Act. Take a wild guess. Yes, the answer is 4.2. Yes. Now take a wild guess about the section number for fitness for purpose. Take a wild guess. This was a trick. It's a trick because the answer is section 4.4 and 4.5. And I'll tell you why it's 4.4.4.5. It's because, well, as you said, with 14.3 of the 1979 Act, you know how long that sentence is. That sentence, where the buyer expressly or impliedly makes it known to the seller the particular purpose for which he requires the goods must be fit for that particular purpose unless. That's such a long sentence. So a few years later, when the Supply of Goods and Services Act came in 1982, the drafters of the legislation thought, you know what, that long sentence, we'll just break it into two. So 4.4 says, oh, whether by express or implied, says, and then 4.5 says, implied condition goods must be. So that's all that's happened. But the words are exactly the same as section 14.3. It's just split into two bits, 4.4 and 4.5. But I'll tell you what, in your exam, if you're answering a question on the 1982 Act and you call it section 4.3, we're going to give you that mark. All right, so forget the detail. 4.4.4.5, if you can't remember that, don't worry about it. I'll just give you the mark anyway. You say 4.3, fine, you get the mark. All right, but essentially, you've guessed completely right. Okay, let's just finish off. What about sample? Under the 1982 Act, what's section number for sample? Yes, 5. Exactly perfect. Exactly perfect. Oh, actually, do you know, I'll tell you what. One thing is missing. You tell me, which section number in the Sale of Goods Act says, if the breach is so slight that it is unreasonable for the buyer to reject, the court has a discretion to treat that breach of a condition as a breach of warranty only. What's section number under the Sale of Goods Act 1979? Perfect. The answer is 15 big A. You know what? The 1982 Act has exactly the same thing. So now you take a wild guess what the section number is under the 1982 Act. Excellent. That is perfect. The answer is, yeah, section 5A. So you see, it's not so difficult to know section numbers. Now, the Supply of Goods and Services contract is a very popular exam question. When goods supplied are rubbish, you use exactly the same cases as we did under the Sale of Goods Act. Satisfactory quality, fitness for purpose, description, everything is exactly the same. So there is a huge overlap between Sale of Goods Act questions and on sections 13 and 14 of the Sale of Goods Act questions and the supply question, which is why if you are going to be revising sections 13 and 14 of the Sale of Goods Act exam question, if that's what you're intending to revise, then you might as well revise for the 1982 Act question because they overlap. You already know every detail you need for description, quality, fitness. So that will be exactly the same under the supply answer, except it's a different section number, and all you need to do is delete the 1. It's 3 and 4.2, 4, 4, 4, 5. You know the same. There are only 4 section numbers under the 1982 Act, which are completely different because there's no equivalent under the Sale of Goods Act. So under the 1982 Act, the only section numbers which are completely different is 13, 14, 15, and 16. Care, time, price, and uptime. So let's look at these in turn. Section 13, care. Section 13 says It is an implied term that the supplier carrying out the service must carry out the service with reasonable care and skill. Essentially, this is common law negligence. This is not strict liability. In other words, the supplier is only liable if he performs with some element of fault. The standard applied to the breach is common law negligence. So if you act with the care and skill of a reasonably competent member of that profession or trade, then okay, you've not been negligent. Of course, this depends on the facts of each case. Lots and lots of cases. We're only going to look at very few. Bolam against Friern Hospital. A mentally ill patient was undergoing electrotherapy. The doctor did not give any relaxant drug. The patient suffered a serious fracture. The patient sued the doctor in negligence. The House of Lords said the doctor was not in breach of duty. There was divided opinion amongst medics whether the drug should be given. Because if you give the drug, there's a small risk of death. If you don't give it, there will be a risk of fracture. This doctor was not negligent just because some doctors might have given the drug. Note that there are two distinct levels of responsibility. Duty 1 is the duty to exercise reasonable care and skill. Duty 2 is the duty to provide the finished product which is fit for purpose. With duty 1, the supplier is under a duty to exercise reasonable care and skill, so he is liable only if he is professionally negligent. With duty 2, the supplier effectively guarantees the design, or he guarantees that the product will work. Usually, 99.9% of the time, the supplier is only under duty 1. In other words, he must exercise reasonable care and skill. Now, whether a supplier agreed to a higher duty number 2, that depends on the facts of each case. See the case of Greaves against Bainham. Builders asked structural engineers to design a warehouse. They told the engineers that the warehouse was needed to store oil drums on the first floor, which would be moved and stacked by forklift trucks. When the warehouse building was complete, they found that the concrete floor had already cracked. The Court of Appeal said the engineers were in breach of both duties. They were in breach of duty 1 because the engineers were negligent, they did not exercise reasonable care and skill. They were also in breach of duty 2. The engineers knew the warehouse was needed to store oil drums. The engineers had impliedly warranted that their design was fit for that purpose. So the engineers were liable. Lord Denning was the judge in this case. He said that usually the standard expected is merely the common law standard of reasonable care and skill. That means duty number 1 is the norm. Denning gave an example. He said, a surgeon does not guarantee to cure a patient, merely that he will exercise reasonable care and skill. Similarly, Denning said, a solicitor does not guarantee to win the client's case. So the general rule is that the higher standard of care, in other words, duty number 2, will not be imposed on the supplier unless it was clear on the facts that the parties intended for the result to be guaranteed. Usually, the supplier is only expected to perform to a reasonable competence. It is rare for the supplier to guarantee that a design is suitable for the intended purpose. It generally needs to be an express term in the contract. But it is possible the court will imply a term if the buyer expressly tells the seller the purpose of the work and he relies on the seller's skill and judgment, like what happened in Greaves against Bainham. Now, if a supplier holds himself out as an expert, in other words, a higher standard then would be required. For instance, if the supplier says, I'm a racing driver, or I'm a specialist structural engineer. Price might affect what standard is to be expected. So if I take my car to be repaired, the standard I can expect might depend on whether I took the car to a cheap garage or I took it to Mercedes-Benz dealership. So price sometimes is relevant. Lord Denning, in Greaves against Bainham, he mentioned the case of Samuels against Davis. It's a good case to illustrate the two duties. In Samuels against Davis, a dentist was under a contract to make dentures for a client. The question for the court was whether the dentist must exercise reasonable care and skill, in other words, duty number 1, or is he obliged to ensure that the dentures are fit for purpose, in other words, under duty number 2. The Court of Appeal said that there is an implied term that the dentures must be fit for the intended purpose, in other words, the higher duty number 2 standard. Now, Dupac's quote is in your handout, so please just read that in your own time. The judge said, a dentist making dentures is not the same as a dentist removing a tooth. Dentures must be fit for purpose, whereas when a dentist removes a tooth, he is expected to exercise reasonable care and skill only, so no higher duty is expected. Whether a higher obligation is expected ultimately depends on the intention of the parties. When this point comes up, you have to talk about platform funding against Bank of Scotland. It's a very important case. A bank asked the surveyor to value a part-built house for mortgage purposes. The bank told the surveyor to contact the borrower to arrange a viewing. There were lots of part-built properties on the same site. The borrower deliberately took the surveyor to a wrong property. Based on the valuation, the bank loaned money secured on the property. When the borrower did not keep up mortgage installments, the bank wanted to repossess the house. It was only then that the bank found out that the wrong property was valued. The real property had a much lower valuation. The bank sued the surveyor for loss. Court said, yes, the surveyor was liable. Yes, the surveyor did exercise reasonable care and skill in the valuation, but the contract with the bank imposed an absolute obligation to inspect and value the correct property. The Court of Appeal confirmed that usually a supplier is only expected to exercise reasonable care and skill, in other words, only duty 1. He can agree to a high obligation, but would need special facts or the contract contain clear language. Courts are reluctant to imply that the supplier guaranteed a result. You see, in platform funding, the bank's instructions were very clear. Inspect and value the correct property. By accepting those instructions, the surveyor undertook an absolute obligation to inspect that particular property. The surveyor issued a certificate to say they inspected the property, and this was not true. They valued the wrong property. This was a breach of contract, even though fraud was involved. So the surveyor was in breach of contract, even though he exercised reasonable care and skill. You see, platform funding was a pretty harsh result, actually, because the surveyor was innocent after all. It was the borrower who was fraudulent. The borrower deliberately took the surveyor to the wrong property. But then you see, the bank was also innocent. The Court of Appeal felt that the bank was less well placed than the valuer to avoid fraud. Another reason why this was a harsh decision was because the valuation fee was only £250, whereas the bank's loss was £30,000, which the surveyor must pay. But you and I already know it is not the amount of loss which determines recoverability. It's the type of loss. We saw the pigs case of Parsons Livestock against Utley Ingham. But hey, what about someone new or someone who's just a learner? What standard can we expect? Well, the case is Nettleship against Weston. A girl was taking driving lessons from a friend. During one of these lessons, there was an accident. Her friend injured his knee. He sued the girl in negligence. The girl argued the standard of care should be lower for a learner driver. The Court of Appeal said no. The learner driver is expected to meet the same standard as a reasonably qualified, competent driver. So you see, if a construction company employs inexperienced or junior workers, they'd better watch out, because the standard expected of inexperienced workers is the same as that expected of a reasonably competent construction worker. All right, let's look now at time. Section 14 says, where time for service is not fixed, there is an implied term that it must be done in a reasonable time. This depends on the facts of each case. So the question on the chat thing is, the duty of care owed by a learner driver to the public, including passengers, was to be measured against the same standard as that would apply to any other driver. Correct. The answer is yes. Looking at time. Now, if time is not fixed for performance, then there is an implied term that the supplier must complete the work within a reasonable time. This is no more than a common law rule. The common law rule implies that work should start and complete within a reasonable time. Of course, this always depends on the facts of each case. Charnock against Liverpool Corporation involved a car which was damaged in an accident. The owner took the car to the garage for repair. Now, the garage didn't say how long it would take, but because it was very busy, they were short-staffed and they prioritized other work, the garage took 8 weeks to do the repair. Average time was just 5 weeks. The car owner was now sued for the cost of hiring the car for 3 weeks. 8 minus 5 weeks equals 3 weeks. The court said the garage was in breach. 8 weeks was beyond a reasonable time to repair. So yes, the car owner can get the cost of 3 weeks car hire. We also know the case of Charles Rickards against Oppenheim. We already looked at this case when we were discussing time of delivery. This was the case about the Rolls-Royce chassis. The Court of Appeal said the buyer was entitled to refuse to take delivery of the chassis. The buyer's notice made time of taking delivery of the essence. Let's look at section 15, price. Section 15 says, where no price is fixed under the contract, it is an implied term that the supplier will charge a reasonable price. Now, this is always a question of fact. Reasonable price is usually market value. Foley against Classic Coaches is a standard authority. In Foley, the seller owned a piece of land. He sold part of it to the buyer for his coach operating business on condition that the buyer buys all the petrol for his coaches from the seller's other half of the land. After a few years, the buyer wanted to buy petrol from somewhere else. The buyer argued, hey, a contract which does not fix the price of petrol, that's too vague to be enforceable. The court said this was an enforceable contract. The court implied a term that the seller will sell at a reasonable price. So price itself is never a problem. If you don't agree a price, never mind. The courts will always imply a term as to reasonable price. But courts will not enforce agreements to agree. May and Butcher against the Crown involved a government contract to provide a company with surplus material. They said that the price and dates of payment and details were to be agreed from time to time. The House of Lords said, no contract. A contract leaving open the price, generally speaking, as I say, is not a problem because courts will just infer a reasonable price. But the parties in this case specifically stated they would agree to agree. In other words, sometime in the future. Agreements to agree are generally not enforceable. They're just too vague. Supposing a supplier quotes a price or he gives an estimate, are these fixed prices? Well, price quotes and price estimate are two different things. A quote is usually an offer to do the work and supply the materials. You'd expect a quote to be precise. In other words, something which is capable of acceptance. At least the price calculation needs to be fixed. An estimate is very different. It's just a rough estimate of cost. The amount is not binding. The price might increase for various reasons, but just because the supplier uses the word estimate, it does not mean it is an estimate. It's a good start, but it's not conclusive. Sometimes an estimate can amount to a firm offer. You know from contract law that a counter offer kills the original offer, Hyde against Wretch, and that the only last offer survives and is available for acceptance. The case you also know from contract law is Pickford's against Sellers Tika. I'll remind you of this case, but you did this in contract law. Pickford's involved a removal company who quoted for moving office furniture and equipment to new premises. The removal company sent a fax dated the 13th of September, which said, budget estimate £100,000 based on a rate per lorry load. On the 27th of September, the removal company did a full survey and they sent a fixed price quote, £99,000, subject to confirmation by the office company. The office company sent a fax headed confirmation that agreed to the 13th of September quote, and they said the cost must not exceed £100,000. The removal people did the office location job and they submitted the invoice for £99,000. The office refused to pay more than £33,000, in other words, the rate based on per lorry load, according to the 13th of September quote. Question for the court was how much was payable? The answer is it depends on what was the contract. In other words, where was the offer and acceptance? The Court of Appeal said the 13th of September offer was terminated by the second offer on the 27th of September. The officer's confirmation, in other words, their acceptance, referred to the 13th offer, which had already been withdrawn. So the officer's confirmation was in fact a counter offer, which the removal people accepted by conduct. So £33,000 was what was payable. What is clear is that if the method of calculating the price is clear, the estimate can be a firm quote, a firm offer. See, in Pigford's against Celestica, the price was based on a rate per lorry load. So the parties don't know exactly how many lorries are required, but they are agreed on the price calculation. So the rate per lorry load would be a firm quote. Or another example is, I agree to install a new door lock for you. I say my labor charge is $500. Here's the list price. Here's a list price of locks with different prices. You just choose one of these. Well, if I say that, then my quote is a firm offer. So yes, the locks have different prices, but you choose which lock you want, but my labor charge is $500. That quote becomes a firm offer. Let's look at two cases and compare them. Croshaw against Pritchard. Consultants were sent some drawings and specifications to builders. The builders were asked to tender for alteration work. The builders sent in a document which was headed estimate. It is our estimate to carry out the alterations in accordance to the drawings and specifications is £1,230. The consultant accepted that estimate, but then the builder refused to go ahead. The consultant employed another builder, but builder number 2 charged more for the work. The consultants now sued builder 1 for the higher cost. Builder number 1 argued, hey, we only submitted an estimate. It was not a firm price. Court said it was a firm offer. So you see, just because the supplier calls his price an estimate is not always clear enough that it is only an estimate. It needs to be more. It needs to say, no, this price is an estimate only and subject to change. It must be made much clearer. There should be no ambiguity in the document. Compare Croshaw with Sites against Packham. This case involved home improvement. The builder submitted an estimate of cost. He said £88,000 based on approximate materials cost and approximate labour cost. When the work was completed, the builder submitted a higher invoice, which the homeowner refused to pay. The homeowner said, hey, the builder had submitted a fixed price. The Court of Appeal said, not a fixed price. There is no magic in the word estimate. You must look at the substance and not the form. Here, the homeowner did not provide a complete specification for various items of work, like the bathrooms. The court said it is unlikely that the builder would take the risk of a fixed price quote. That's why he used the words approximate materials, approximate labour cost. So the homeowner must pay a reasonable price. Now, if the price is an estimate, the final price should be similar, in the same kind of ballpark. Now, if the final price is higher, sometimes it's okay, but the supplier needs to justify the higher sum as reasonable. Maybe, I don't know, he needed more spare parts, or maybe he found asbestos when he was doing building works. So if the builder submits an invoice which is higher than expected, then you will need to advise the client to get expert evidence as to what the reasonable value of this additional work or material is. If the estimate is totally rubbish, if it's totally inaccurate, and the final price is zillions more, then the seller may be liable for breach of Section 15, breach of the implied term that the supplier will charge a reasonable price. Now, of course, there's also the possibility of an action for misrep. The supplier makes a false statement of fact, intending the client to be induced into entering into the contract, and the client was induced. The remedies, of course, depends on the type of misrep: fraudulent, negligent, innocent. Dig out your contract law notes and just refresh your memory a little bit. Don't relearn the cases off by heart. Just reread your misrep notes. Now, sections 13, 14, and 15 are terms. Remember the classification of terms. There are three types of terms. There are conditions, there are warranties, and there are innominate terms. Now, the remedies are very different, very different. Now, sections 13, 14, and 15 of the 1982 Act are invariably treated as intermediate terms. So the court will assess how serious the breach is. If the consequences of the breach goes to the root of the contract, then the courts will treat the breach as a breach of a condition. In other words, fundamental breach, and the innocent party can rescind. If the consequences of the breach does not deprive the innocent party of substantially what was to be gained under the contract, the court will treat the breach as a breach of warranty only. Now, there is a group of 4 cases. The leading case is Hong Kong Fur Shipping against Kawasaki Kaisen. You know this case. I'm not going to go through it again. From contract law, you also know about the other 3 very important cases about innominate terms. The Hansa Nord is about citrus pulp pellets. We've already reminded ourselves of Reardon against Hansen. This is the case about the oil tanker, which was built at a yard 300 miles away. We have also revised the case of the Michaelis Angelos, when the ship was not ready to load the goods on the 1st of July. This was a very serious breach, entitling the innocent party to treat the breach as a repudiated breach. Now, these cases are in your contract law manual, so dig out your notes on them, because in the exam, when you are asked to advise either the supplier or the customer, and there's a breach of one or more of the provisions of the Supply of Goods and Services Act, for sure, 100%, you need to discuss their rights and obligations. Care, time, price are implied terms. They are innominate terms. So you must discuss the group of 4 cases. So dig out your contract law notes, please. Finally, just mention section 16. Let's look at section 16. Section 16, all section 16 says is that these terms, care, time, price, may be varied subject to UCTA. As simple as that. Now, let's look at a sample problem question, because these questions, again, I'm telling you, they just come up all the time. So let's see how they come up. It's on page 56 of your handout. I'm going to read this out loud once with you, and then I'm going to give you 1 minute to reread. Let's read it together. This is on page 56 of your handout. Gloria, sorry, just give me a second. Right. Gloria has recently purchased a derelict building in the centre of Manchester, which she intends to convert into a Chinese alternative therapy business. Being keen to get the renovations and building work done as quickly as possible, she contacts Jack, a local builder recommended to her by Sherry, a close friend, although perhaps not for much longer. Jack comes to the premises to evaluate the work to be done. Following much consideration, he explains to Gloria that, oh, it's a big job and won't be cheap. I would suggest a figure of £100,000, but don't quote me on that, as the price of raw materials and labour does tend to fluctuate a little. He estimates that the job will take no more than 6 months to do, and that he could do it sooner, but feels sure that she would want it doing professionally. A couple of weeks later, Gloria contacts Jack to accept his terms, and they agree a start date of the 1st of February. Although Jack commences the work promptly, Gloria notices that he soon begins to disappear for long periods, leaving inexperienced workers to carry out all the work. By the start of March, she is concerned that the work will not be finished by August. She immediately writes to Jack to reaffirm that just in case there was any doubt about my desire to have the work finished by the start of August, I want to make it clear that I expect the work to be done by then and all your materials removed so I can open for business. Jack returns soon after and continues with the work. However, he does not finish until the end of September, which has prevented Gloria from opening for customers. In addition to the considerable loss of custom, she is shocked to receive Jack's account in which he claims the sum of £125,000, citing the increased costs of building materials. Furthermore, the work is generally shoddy. More specifically, the lighting does not work. The new windows admit water when it rains, and the toilet will not flush. She approaches Jack, who refuses to remedy any of the alleged defects, stating, "What do you expect for £125,000? Gloria threatens to counterclaim for damages. Advise Gloria over any contractual claim she may have pursuant to the Supply of Goods and Services Act 1982. Okay, let me give you just a minute to reread that so you're clear about the facts in your head. Let me give you a minute to reread. Goods Act we need to look at, or the 1982 Act. So even in this question, if this question is asking you to advise the client in relation to the 1982 Act, you need to check that it is the 1982 Act that applies. To do that, check that the CRA does not apply. Once you've done that, make sure it is the 1982 Act that applies and not the Sale of Goods Act. Of course, exam technique will tell you if there is already a question on the Sale of Goods Act, then you won't be given two questions on the same thing. So this one really does have to be the 1982 Act question. We'll do the detail later, but let's just do the rough work first. Okay. In the same way with the Sale of Goods question, start off by being very clear about what your client is complaining about. In the same way we did with the sections 13 and 14 questions, identify what the problems are here. What the problems Gloria has with the building work. What is she complaining about? You tell me. All you need to do is write down what the client is complaining about. So you tell me, what's she complaining about? What's she complaining about? What's Gloria complaining about? Why is she asking us to advise her? Why? What's she complaining about? Yeah, she's got a problem with the lighting, right? Something to do with the lighting doesn't work. That's no good. What else? Yeah, some problem with the windows. Totally rubbish. Windows are rubbish. Something about, yeah, it leaks. There's less water coming in. Yeah, toilet is not flushing. That's no good either. Wow, it costs more than 100,000. More than 100,000. Anything else? Anything else she's complaining about? Yeah, it's very late, because they did kind of agree and talk about a date, but it's very late. Anything else really? No, I think that's just about it, wasn't it? So this is the neater version of what we just talked about. Now, what Gloria wants to know is whether these things that she's complaining about, she wants to know whether these things amount to breaches of terms of the contract. So you've got to take each of these in turn and consider the breach of what it might be. Now, we know we're talking about the 1982 Act. So let's take a 10-minute break now. Have a look at the problems that our client is complaining about. And you tell me next to each of these things what we need to discuss in relation to the 1982 Act. All right, we'll take a 10-minute break try and work out what is it we need to discuss under the 1982 Act in relation to each of these complaints. All right, I'll see you in 10 minutes. Okay, so we're doing this question on Gloria. So we're just doing rough work at the moment. So take each of these complaints in turn and consider what breach it might be. Now we know we're talking about the 1982 Act. So the first thing I've got written down there is, what about the building work taking too long? Breach of what might that be? What is it we need to discuss? It's just taking too long. Breach of what do we need to discuss in relation to that problem? Our client's complaining that it's just taking too long. Thank you very much. Yes, correct. I agree. So the answer to that is section 14, to do with time. What about Jack charging too much for the work? What's that about? What do we need to discuss? I know we're only just doing it now, but you guys are so on the ball that I think you can answer this question already. Yes, I 100% agree. Section 15, to do with price. What about the lighting? It's not working. What do we need to discuss there? To do with lighting, it's not working. Well, you need to be a little bit careful here, because it kind of depends, doesn't it? I think you're right, there is a possibility of 13. But you see, the lights are not working. What makes me query is because I'm wondering whether the light fittings themselves are faulty. Because if it's the light fittings themselves which are faulty, then we're talking about a breach of section 4, to do with the goods. Of course, as you said, maybe it's to do with bad workmanship. Because if that's the case, then I agree with you. It will be a breach of section 13 care. I agree. So actually, as far as the lighting's not working is concerned, it could be section 4. It could be section 13. What about, I'm just doing rough work for the moment. Yeah, look, 4.2, 4.3, I said we will give you the mark for 4.3. But remember, under the 1982 Act, the tiny detail is not 4.3, it's 4.4, 4.5. There's a tiny detail, and if you called it 4.3, we'd give you the mark anyway. We really don't care. Too minor a detail. Now, what about the windows? What about the leaking windows? That's the same, isn't it? Because either the windows are faulty, in which event it's a section 4 claim, or maybe it's bad workmanship, which means 13 care and skill again. All right, so this could be 4 as well as 13. And then what about the loo that's not flushing? Well, if the toilet itself is faulty, then we're talking about section 4. If it's the service, which is rubbish, then we're talking about section 13, care and skill. So even the toilet, that's also 14 and 13. Okay, now that you've done that, you have a choice how you answer the question. You could either deal with each of these problems in turn. So you could discuss the issue about Jack taking too long to complete the work, and then discuss what the problem is about Jack charging too much, and you just carry on like this until you complete all these things. Yes, you can do it that way. No problem at all. You will get the marks. I personally prefer to deal with the problem in the order that statute sets it out. It's also the same in our main lectures too, and also how I handled the sections 13 and 14 sale of goods question about Mary and her washing machine. What I am saying is, I would rather deal with section 13 first. That's the implied term that the supplier must act with reasonable care and skill. Then I will deal with 14, implied term as to reasonable time. Then 15, implied term that the price for the service is a reasonable price. Now I know there's the question of whether the goods are faulty, but that only ever applies to section 13, bad workmanship. There is no right or wrong way of doing this, but because these questions are essentially always the same, I would rather deal with the problem always in the same way, chronologically. So I want to deal with 13, then 14, then 15. I just want to do it automatically. I don't want to think about it in the exam. I just do it the same way. Okay, if that's the case, and I want to discuss section 13 care and skill problem, so if I want to put down here care and skill problem, section 13, then the care and skill problem first. Why are these things not working? Well, they're not working. We know it's the lighting, the windows, and the loo. Those are not working. We said it could be because of faulty parts. So that would be a breach of section 4. Or it could be because of bad workmanship. So these things are not working, all right? No good. These are not working. The loo, the lights, the leaking, not working. We said if it's to do with faulty parts, the loo itself is defective. The windows themselves are defective. If that's the case, we're talking about section 4. Or it could be because of bad workmanship. Now, bad workmanship is definitely section 13, for sure. Now, in fact, there is also one more thing we ought to query. If it could be because of something else. Maybe you're right, the fact that the windows don't work, the loo, yeah, it could be the item itself which is defective, so it's breach of section 4. Or it could be bad workmanship, that would be a breach of section 13. It's also worth mentioning that it could be because of something else. What's something else? Well, it could be just pure coincidence, can't it? I mean, maybe what happened, the lights don't work or the toilet's not flushing, maybe it has nothing to do with Jack. If it doesn't work because of something totally unrelated to Jack, then Jack won't be liable. Just query that. That's all, not a big point, just query that. So certainly the very first bit here will all be section 4 and section 13. The next section number I want to deal with is to do with section 14. That's because it took longer, took ages to do it, ages to complete. That is section 14. Then, of course, you must discuss the fact that the price is higher. So then this is to do with 15, right? So I'm going to answer it in terms of 13, 14, and 15. After all of that, don't forget to deal with remedies. Now, remedies is always important because that's what ultimately any client wants to know about. Okay, so the neater version of what I've just said is on the screen now. Okay, so let's now answer this question in full, and I'll show you the standard that we expect. Okay, our client is Gloria. She is the one who asked Jack to do some renovation works. Now, Gloria is unhappy and she wants to know what claim she might have against Jack. To advise her, we need to look at the terms of the contract. We're asked to advise her about a potential claim under the 1982 Act, but we need to check that the 1982 Act applies anyway and not the CRA. The CRA only applies to consumer contracts. In other words, when a trader supplies goods, digital content, or services to the consumer. The definition is in section 2. A trader is someone who acts in the course of business, Now, Jack is clearly a builder. Yes, he's a trader. A consumer must be an individual natural person. Companies cannot be consumers. Now, even though Gloria is a natural person, she intends to run a therapy business. Businesses cannot be consumers. She can only be a consumer if she does not contract mainly for business purposes. So conclude at your introduction that Gloria is not a consumer. So it's not the CRA that applies to this contract. Then query if this is Sale of Goods Act or the 1982 Act. What is the nature of the contract? Remember, the Sale of Goods Act only applies where the main purpose is a sale of goods. Look at the substance of the contract. Here, the substance is predominantly for building work. In other words, requiring the exercise of skill and labor, even though some goods, some parts will be involved. Your case authority for your intro is Robinson against Graves, where the court held that a painting, a picture is primarily a contract for services involving the skill of an artist. So, of course, ultimately, whether the contract is mainly for goods or mainly for services depends on the intention of the parties. So if the parties intend for the transaction to be a sale, the Sale of Goods Act applies. Conclude this bit by saying it is more likely that Gloria's contract with Jack for building services is governed under the 1982 Act rather than the 1979 Act. That's your intro. We've already listed out what Gloria is complaining about. So now just go through and discuss whether these problems amount to a breach of a term of the contract under the 1982 Act. Now, as far as things don't work is concerned, well, there are three things: the lighting, the windows, and the toilets. Say straight away that it is not clear what caused these three things not to work. We said we ought to query if it was just a matter of coincidence. Because if the defects are not the result of Jack's work, but it's just pure coincidence and it is caused by an unrelated source, Jack will not be liable. On the other hand, if the defects do relate to Jack's work, we're not sure actually if the defects are a result of faulty products supplied or incorrect installation of the products. Gloria needs to find someone to analyze these faults to see if it was because of defective parts or bad installation. Because if it was because of faulty parts, then section 4.2 and section 4.4.5 kick in. This is essentially the same as section 14 of the Sale of Goods Act. Lights, windows, loos must be of satisfactory quality and fit for purpose. This is an implied condition. Go through section 4, subsection 2. Go through everything we know about satisfactory quality. It includes the 2 exceptions, get rid of them. And remember, satisfactory quality depends on whether a reasonable person would regard the goods as satisfactory, taking into account description, price, and all other relevant circumstances. Now, look, you have to go through each of these as well. Description, remember, brand new, second hand, price, was it high price, low price? Everything we've already done. Under the 1979 Sale of Goods Act, use the same cases, the same words, bring it in here under section 4, because the goods might be unsatisfactory, the goods might be unfit. So if you are doing, in the exam, if you are doing the 1979 question about sections 13 and 14, if you've done all the cases under section 14 to do with Bernstein, to do with second-hand goods, new, if you've done that, you need to write it out again under this 1982 Act question. As I said, there's a lot of overlap. So when we're talking about goods being faulty, if you've done the sale of goods question, you need to rewrite all the things you said about satisfactory quality, rewrite it in your 1982 question, because you're saying it could be the windows are faulty, it could be the toilets are faulty, and so forth. You just rewrite those things. But all those cases, exactly the same. So just go through the definition of satisfactory quality. Now, we're not told, of course, what proportion of the price was paid for these 3 items. But I think the price paid is significant if the invoice is somewhere between 100 and 125,000 pounds. Go through aspects. We've gone through all that stuff. Aspects include freedom from minor defects. Remember, this does not mean that goods need to be perfect. In Darren Egan against Motor Services, the court said freedom from minor defects did not mean literally every minor defect. It depends on whether a reasonable person would think the goods are satisfactory or not. But the defects in this question are more than minor defects. Another aspect is durability. We're not told how soon after Jack completed the work when Gloria discovered that the lights were not working, or the windows were leaking, and the loos don't flush. But the principle is that goods needs to last for a reasonable length of time. This is true even for second-hand goods, for heaven's sakes. Crowther against Shannon Motors. Of course, goods do not need to be fit for every conceivable purpose. Balmoral against Borealis. Give the facts. Storage tanks made from borosine the buyer bought proved useless. The buyer claimed the borosine was not satisfactory nor fit. The court said the seller was not in breach. There was nothing wrong with the borosine. It was the buyer's own production process and misuse of the borosine that caused his loss. So all we're saying here is that we are assuming that Gloria used the lights, the windows, and used the loos properly and in a normal way. And if she did, then the lights, windows, loos, they will have failed their primary purpose. So it is difficult to see how a reasonable person would regard these goods as satisfactory. As I said, all the cases we know under the 79 Act, you use the same cases and you repeat it in this 1982 question. Hey, we forgot to add something to our rough work. We forgot this with a section 13 and 14 question about Mary and her washing machine as well. Let's add it in. Let's make sure we add this into our rough work. What's the section number that says, if the breach is so slight that it is unreasonable for the buyer to reject, the court has discretion to treat the breach of a condition as a breach of warranty only. What is the section number of the 1982 Act? Fantastic. Thank you very much. You're all correct. So section 5A. Perfect. Section 5A overrides section 4 of the Sale of Goods Act. So the burden of proof is on Jack to prove that the problems with the lights, the windows, and the loos, he must prove they are so slight it would be unreasonable for Gloria to reject the goods. But here, he's not going to manage to do that. The court is not going to exercise 5A discretion. because the problems are not slight. I think we can be pretty sure that if it is the goods which are faulty, the court won't exercise 5A discretion. Now go on, having discussed quality, now go on to discuss fitness. 4.4.4.5 says, where the buyer expressly or impliedly makes known all the stuff that we know, goods must be fit for that particular purpose. But the lights, windows, the loos, they only have one purpose. We know where the description of goods points to one purpose only, goods must be fit for that particular purpose. Use the same cases that we know from before. Priest against last, hot water bottle. Grant against Australian knitting, underwear. Griffiths against Peter Conway, wool jacket. Always mention the exceptions. The exceptions, of course, won't apply because it is reasonable for Gloria to rely on Jack's skill and judgment to select goods suitable for purpose. Now, breach of section 4 is a breach of a condition. I'm going to deal with remedies later on, all in one go in the final paragraphs. Now, what we did say, we said we're not sure why the lighting windows and the loos are not working properly. If it was to do with the faulty parts, we've just discussed that under section 4. If it has nothing to do with the parts supplied, in other words, the parts themselves is okay. But what it's got to do is Jack's faulty workmanship. Well, as Jack does renovation work in the course of business, section 13 implies a term into the contract that Jack must exercise reasonable care and skill. Explain that this is not strict liability. In other words, Jack is only liable if he performs with some element of fault. The standard applied to the breach is common law negligence. So Jack must act with the care and skill of a reasonably competent member of that profession or trade. This depends on the facts of each case. Bolam against Friern Hospital. Go through the facts about the doctor who did not give a drug to the mentally ill patient. I won't bother to remind you of the full facts because we did it just before the break. The court said that this doctor was not negligent just because some doctors might have given the drug. So Jack is expected to act with the care and skill of a reasonably competent renovations building contractor. There was nothing special about the work he was asked to carry out. He's supposed to install lighting. He's supposed to fix new windows. He's supposed to fix the loo. I mean, this type of thing seems like normal building contractor work. If lighting, windows, the loo, if that sort of work needs a specialist, like a specialist electrician, then I think we would have expected Jack to have declined taking on the job in the first place. He should have referred Gloria to a specialist. Jack clearly regards himself as having sufficient expertise to agree to take on this job. So the question is whether Jack is in breach of his duty to take reasonable care and skill in carrying out the renovation work. In fact, section 13 is no more than a common law rule. But under the common law, there are two distinct levels of responsibility. Go through this. The first is the duty to exercise reasonable care and skill. This is the same as section 13. The second is the duty to provide a finished product which is fit for purpose. With the first, in other words, the duty to exercise reasonable care and skill, the supplier is only liable if he has been professionally negligent. With the second, the supplier effectively guarantees the design or that the product will work. Whether Jack agreed to the higher duty depends on the facts of the case. Go through Greaves against Bainham. I won't remind you of the facts because we literally did this just before the break. In this case, Greaves against Bainham, the engineers were in breach of both duties. Denning was the judge in Greaves against Bainham. He stressed that the usual standard expected is the common law standard of reasonable care and skill. Denning gave two examples, and you can give this in your exam. Say so. The two examples he gave, he said a surgeon does not guarantee to cure a patient. The surgeon's duty is to exercise reasonable care and skill. In the same way, a solicitor does not guarantee to win a case. The general rule is the higher standard of care will not be imposed unless it was clear on the facts that the parties intended for the result to be guaranteed. Go back to your question, tie it all in. We're told that Jack is a local builder. I don't think this means Jack held himself out as a specialist or an expert. I mean, in Greaves against Bainham, okay, the engineers were specialists. They were the consultant structural engineers. Here, Jack is just a local builder. It is highly unlikely that Jack expressly guaranteed an outcome. I think it is highly unlikely the courts will imply the higher duty. Mention that Denning in Greaves talked about Samuels against Davis. Samuels against Davis is a good case to illustrate the two standards. Remember, it was about a dentist. The judge said a dentist making dentures is not the same as a dentist removing a tooth. Dentures must be fit for the intended purpose, whereas when a dentist removes a tooth, his duty is to exercise reasonable care and skill. No higher duty would be imposed. Ultimately, though, whether a higher obligation is expected depends on the intention of the parties. Having said all of that, you then need to go on to discuss platform funding against the Bank of Scotland. It's an important case, so give the facts. It's about the surveyor who valued the wrong property. The court said, although the surveyor exercised reasonable care and skill in his valuation, his contract with the bank imposed an absolute obligation to inspect and value the correct property. So in this case, the surveyor was liable for the bank's loss. As I say, unless there are special terms, there is normally no guarantee of a result, and the courts are reluctant to imply that a supplier guaranteed a result. But platform funding was just a little bit different, because the surveyor's valuation of the wrong property was a fundamental breach of contract. In our question, Jack's just a local builder. I don't think the higher standard of care will be imposed. So Jack and his workers need only perform to the common law standard of reasonable care and skill. But even so, see, the new windows are leaking, the loo is not flushing, and the lights are not working. I'm not sure Jack did even that. I don't think his workmanship satisfies the common law standard. And by the way, we're told in this question that Gloria says that some of Jack's workers seem inexperienced. The point we want to make is incompetence due to inexperience is certainly no defence. The case authority is Nettleship against Weston. Go through the facts. The court said a learner driver is expected to meet the same standard as a reasonably qualified, competent driver. So if Jack used inexperienced workers, we can tell Gloria that the standard to be expected of them is the same standard as reasonably competent construction workers. Now, having said all of that, we need to know why the defects arose, of course. So we should invite an expert in to help analyse the reason why the lights, windows and the toilets don't work. I mean, was it the installation of the new windows, for instance, carried out to the standard expected of a reasonably competent builder? But to be frank, the defects seem pretty basic, don't they? The new windows are leaking. The loo does not flush. The lighting is not working. Well, sounds like pretty basic building contractor work. I don't think Jack carried out the work to a competent standard. I don't think Jack nor his workers took reasonable care to do the work. So this amounts to a breach of Section 13. Now, Section 13 is an intermediate or innominate term, of course. So the remedy depends on the consequences of the breach. Now, we know Hong Kong First Shipping against Kawasaki Kaisen. Are the consequences of the breach so serious so as to deprive Gloria of substantially the whole benefit of the contract? Well, yes, because until the building work was complete and safe, she could not use the building for her therapy business. And of course, if the lighting is not working, that could be a health and safety issue. If employees or customers are stumbling in the dark and they hurt themselves. If it is possible to remedy the defect by getting another builder to come and sort out the problems of the windows, the electrics and the loo, the courts will award Gloria damages. So if the defects can be remedied, the breach of Section 13 may be treated as a breach of an intermediate term, more like a warranty. On the other hand, if the court considers that the defect means that Gloria is deprived the use of the building as a therapy centre, and therefore the substantial benefit of the contract, the court may treat the breach of Section 13 as a breach of an innominate term, more like a condition. Okay, that's fantastic work on the first bit. Now we've dealt with Section 13, move on to Gloria's next complaint. Gloria now says the work Gloria says the work took too long. So the question on the screen here is, may I check duty 2 would not apply to Jack in this question? Yeah, I don't think it will apply to because he's not a specialist, is he? I mean, he's just a local builder. That's what we're told. He's not like a super duper specialist structural engineer like Bainham against Greaves. So here he's just a normal, ordinary builder. So duty number 2 won't arise. But you just mention it, all right? Now, because obviously you're not given so much information, you're given as much information as you need to answer this question. Gloria now says, oh, the work took too long. The question is, was time fixed for performance? Because you see, in the question, discussions took place. And Jack said that the work would take no more than 6 months. Now, of course, Gloria will argue that this was an express term, that the work would take a maximum of 6 months. What we know is that they agreed, didn't they, a start date of the 1st of February. 6 months means the work ought to be finished by the 1st of August. But even if it was an express term, what type of term is it? I mean, time is not normally of the essence unless parties expressly say so, or unless the nature of the contract renders time of the essence obvious. Even if it was an express term, whether that term is a condition or a warranty, that depends ultimately on the intention of the parties. The case authority is Wickman against Schuler. No need to give the full facts of Wickman against Schuler, which was the case about the 4-year distribution agreement. But it is a House of Lords case. So you could just say that the House of Lords said that whether a term is a condition or a warranty will be decided based on the substance of the contract and the intention of the parties. That will give you the mark, because you ought to mention that case. Now, in this question, the 6 months time was probably not agreed as a condition, because Jack said about 6 months. So maybe there was no agreed deadline. Of course, the contract between Gloria and Jack is a commercial one, and usually time is of the essence in commercial contracts. We know the case of the Michaelis Angelos. The ship was not ready to load the goods on the 1st of June. This was a very serious breach, entitling the innocent party to treat the breach as a repudiatory breach. Yes, we know the contract between Gloria and Jack is a commercial one, but this does not necessarily mean that time was made of the essence. You still need to look at the facts of each case. If the contract does not stipulate that time is of the essence, you need to look at the nature of the contract and the circumstances of the case to see if time was made of the essence. The case authority is United Scientific against Burnley Borough Council. This was a landlord and tenant case about rent reviews. There's no need for the full facts of the case, I think. It will be enough to say that the House of Lords in this case said time is not of the essence unless there were express words in the contract or it was clear from the nature of the contract and the circumstances of the case. Having said all of that, you then go on to say, even if time was not of the essence, section 14 time applies. Now, where time for service is not fixed, there is an implied term that the service is to be done within a reasonable time. Remember, this is no more than a common law rule. It's merely saying that work should start and complete within a reasonable time. As with all common law rules, this ultimately depends on the facts of each case. Give the case of Charnock against Liverpool Corporation. This was about how the garage took 8 weeks to repair a car. Evidence was given that the average time for such repair was only 5 weeks. Court said the garage was in breach. 8 weeks was beyond a reasonable time to repair. That's why the car owner was entitled to recover the cost of 3-week car hire. Gloria and Jack did discuss 6 months. Even if it does not amount to an express term of the contract, the court will take into consideration what was discussed to assess what might be a reasonable time for the work. We're told that at the beginning of March, Gloria wrote to Jack to confirm the deadline of the 1st of August. Yes, the 1st of August was discussed, but Gloria can't just impose a completion date if this was not agreed at or before the contract was made. Unless, of course, I suppose, the deadline is a reasonable one. Case authority, Charles Rickards against Oppenheim. I won't remind you of the facts. It was about the Rolls-Royce chassis. Now, Gloria and Jack did discuss 6 months during their discussions. So maybe 6 months is a reasonable deadline. What happened when Jack received Gloria's letter? We're told that Jack returns to work. Jack did not argue about the deadline. Maybe this indicates Jack is okay with the deadline. What we need to do is we need to find out why the work took longer. About 6 months has become 8 months. Were there unexpected problems with the building work? Or were there unexpected problems with the building itself? Were these factors outside Jack's control? Now, the other point, of course, is we're told that Jack was often missing, leaving his inexperienced staff to get on with the work. Now, if the delay in completing the work was caused because of his use of inexperienced staff, then that is Jack's problem. It is no excuse at all. If there is no good reason for the delay, Jack is in breach of Section 14, the duty to complete the work within a reasonable time. We should get someone in to analyse what might have caused the delay. If Jack is in breach, Gloria can claim for lost revenue that flows from the breach, such as her loss of profit. Now let's look at Gloria's complaint about Jack's invoice. Gloria is saying that the charge is too high. Section 15 says, when no price is fixed, there is an implied term that the supplier will charge a reasonable price. Of course, what amounts to a reasonable price is a question of fact. Reasonable price is usually market value. Foley against classic coaches. Go through the facts. What is a reasonable charge is a question of fact, as we said, but during negotiations, Jack kind of deliberately uses vague language, doesn't he? He suggested, £100,000, but he says to Gloria not to quote him on that. That's pretty evasive. Suggest £100,000 does not sound like a quote, though. A quote is usually a firm offer for carrying out the work or the supply of materials. You would expect a quote to be precise, in other words, capable of acceptance. At least the price calculation has to be fixed. Suggest 100,000 sounds more like an estimate, to be frank, a rough idea of how much it would cost. But just because the word estimate is used, it does not mean that it is an estimate. It's a starting point, sure, but it's not conclusive. Sometimes what is called an estimate can amount to a firm offer. Pickford's against Celestica. Now, I know you know this case. Not only did I remind you of the facts earlier today, but you already studied this case in contract law. Now, the facts of Pickford's are quite complex though, aren't they? Well, not complex as such, but quite tricky to explain. It is an important case though. Because your time is going to be pretty tight in the exam, maybe, and my suggestion is, don't bother to give the full facts of Pickford's, but use the case as authority for the statement that if a method of calculating the price is clear, an estimate can be a firm offer, can be a quote, a firm offer. Because in Pickford's, maybe all you need to say is in Pickford's, the office agreed to a rate per lorry load. They didn't know how many lorries would be required to move the office furniture to new premises, but the court held that the invoice needed to be calculated in accordance to the rate per lorry load. Again, you see, by abbreviating the facts in this way, we know you know the case, because there is only one case in your syllabus about moving office furniture based on a rate per lorry load. This shows you have identified the right case, and we are happy to give you the point. Jack suggests £100,000. We'll compare two cases. Croshaw against Pritchard. Although the builder's document was headed estimate, the court said it was a firm offer. In this question, Jack suggests £100,000 and said, don't quote me. It does sound like an estimate. I don't think it will amount to a fixed quote. But compare Croshaw with Sykes against Packham. The builder submitted an estimate of cost. He said £88,000 based on approximate materials, approximate labour. Court said there is no magic in the word estimate. You need to look at the substance and not the form. You see, in Sykes, the court said it is unlikely a builder would take the risk of giving a fixed price quote. That's why the builder used words like approximate materials, approximate labour. So the homeowner must pay a reasonable price. So I think Jack's suggestion about £100,000 is no more than an estimate, and Gloria needs to pay a reasonable price. Reasonable price is a question of fact, of course. So reasonable price is usually the market value. Really, we need to find out why the conversion costs increase so much. If there is no good reason, Gloria is not liable for the additional amount. If the work took longer than a reasonable period, and that is why the price goes up, Jack cannot recover for the extra amount. Of course, if it was because of his use of inexperienced staff, and that's what caused the delay and an increase in costs, Gloria need not pay the additional amount. But Jack did warn Gloria that the price of materials and labour fluctuates. So really, I think 100,000 was only an estimate. But if it's an estimate, the final price should be similar anyway. £100,000 is ending up £125,000. That's 25% more than what was discussed. The final price is quite a lot higher than the estimate of £100,000. I mean, sometimes it's okay, of course, but Jack needs to justify the increase as reasonable. I mean, did he need more bricks? Did he find asbestos when he was doing building work, so he had to take remedial action? We don't know. So actually, we should get a report done to investigate if there were justifiable reasons for such an increase in costs and time. If the work took more than a reasonable time, and that is why the price increased, for sure, Jack cannot recover for the additional amount. If it was because of his inexperienced staff, as we said, Gloria does not need to pay extra. All right, now let's complete remedies. Now, there are two possible types of breaches here. The first is there could be faulty parts, in which event the breach is section 4. This is an implied condition. We're not 100% sure if it's faulty parts, of course, as we discussed. The problem about lighting, windows and toilets, they could have been caused by faulty workmanship. If it is faulty parts involved, then it's a breach of section 4. This is a breach of a condition, entitling the innocent party to treat the contract as an end and recover for the loss. However, Gloria will not be entitled to treat the contract as at an end if she has affirmed the contract. Remember, with the Sale of Goods Act, the buyer loses his right to reject if he accepts the goods. With the 1982 Act, the buyer loses his right if he affirms the contract. It's not a huge difference between affirmation and acceptance, but affirmation is better for the buyer. The buyer gets a longer time before she is said to have affirmed the contract. Now, whether or not Gloria has affirmed the contract, she would be entitled to treat the contract as repudiated, so she would be entitled to damages for the loss suffered. The second possible breach in this question was a breach of sections 13, 14 and 15, care, time, price. These implied terms are merely terms. They are innominate terms. So the courts will assess how serious the breach is. Gloria will claim for her losses under the normal common law rules of remoteness. That's Hadley against Baxendale. The overall principle is that the purpose of damage is not to punish, it's merely to compensate. You can use the case authority of Surrey County Council against Brodero Homes. It is likely that courts will only allow a claim for actual loss, though, like Bent's Graphics against Fasten. Mention the classic case to illustrate the two limbs of Hadley against Baxendale. Victoria Laundry against Newman. You know this case from contract. This case was about a new boiler which was delivered late to a laundrette business. The owner of the business claimed two things. First of all, the loss of profit because of the delay. She also claimed for the loss of profit on a lucrative government contract. The court said that the loss of ordinary profit was recoverable because it was within the reasonable contemplation of the parties that such a loss would follow. But the court said the owner could not claim for lost profit on the lucrative government contract because the seller did not know about it. Now, in this question, we're not told, are we, what Gloria might have charged for therapy sessions and what she was expecting in normal profits. But she should be able to claim normal loss of profit. We're not told anything about her having any lucrative contracts up her sleeve. But even if she did, unless Jack knew about lucrative contracts, Gloria's damages would be limited to her normal loss of profit. In the meantime, Gloria should not pay the full invoice because this could be seen as accepting this higher price. If Gloria pays some of it, she ought to stipulate that it is subject to proceedings between the parties. When you say, what about consequential losses? I've got it there as my number 2. Because number 2 is consequential loss or special losses. This is essentially the second limb of Hadley against Faxendale. And you've already explained about Victoria Laundry against Newman. You see, my remedies come in a pack of 5. I always mention things in this way. Number 3 on my remedies pack is mitigation. If she needs to open her therapy business quickly, she ought to do what she can by employing a second builder to remedy the defects so she can open her therapy business. Number 4 is non-pecuniary loss. Now, Gloria, of course, hasn't quite started her business yet, so I'm not sure she'd get anything. I mean, what reputation, what goodwill? But anyway, just mention non-pecuniary loss and say that she's unlikely to be awarded any because her business hasn't even started yet. The final point I would raise, point number 5, is type of loss. If Gloria can show that her normal loss of profit for the 2-month delay is substantial, she can claim it. It's not the amount of loss that determines recoverability, it's the type of loss. Full stop. So you see, there's a huge overlap between sale of goods and the supply of goods. Because when it comes down to the goods being faulty, then it's the same case as you apply for satisfactory quality and fitness for purpose. And even when you come down to remedies, there's 5 issues under the 1979 Act, and there's 5 issues under the 1982 Act. So there's lots of overlaps. All right. Now, there are 4 major areas of the Sale of Goods Act we need to look at. Passing of property and risk, we've done. Nemo Dat, we've done. The implied terms under the 79 Act and the 1982 Act, we've also done. We also need to revise exemption clauses. Now, this you handled under contract law, but exemption clauses comes up in a question in its own right in commercial law as well. Well, I think rather than start on it now, we'll end today's lecture. Now, tomorrow is a day off. So when we come back on Thursday, we will start off me reminding you the basics of exemption clauses, and then we'll go into retention of title clauses. All right, so have a great day off tomorrow, and I'll see you on Thursday. All right, see you on Thursday.